Because as we've been talking about and reviewing what's been going on with Michael Proctor, a lot of different names have come up: Brian Walsh, Miles King, and we're going to talk about Miles King here. Michael Proctor has been involved in so many investigations with his time with the state police department. But now that all of these emails and all these text messages came out, we're talking about 13 years worth of text messages, emails, audio clips, pictures. Some of the people who have clients, and we're going to talk about Rosemary S. in a second, her client, Miles King, they want to see what Proctor had to say about their investigation. Did he say how he was handling the investigation? Was he talking to somebody else? Was there any prosecutorial misconduct, I think is the term that's used. So we're actually going to hear from her when she went before the judge and said, Your Honor, we need some of this information, and we think Michael Proctor may have had some issues in our investigation as well. Check this out.
Who represents the Norfolk County District Attorney's Office. I had a conversation with the Assistant U.S. Attorney Lamacchia. My biggest concern is whether or not it's been communicated to the U.S. Attorney's Office and or the federal judge that you and Judge Fournier and everybody else are looking for this February 2024 order. When I had that conversation with Assistant United States Attorney Lamacchia, he didn't indicate that there was a conversation one way or the other. What he said to me is he needed to speak to Mr. Sullivan, and then he would get back to me. When I called again, I didn't get something affirmative in terms of is that being discussed amongst the things that need to get resolved, because this court has made it clear that you're not inclined to make a decision on my request for discovery until we get that order. And I just want to make sure we're not waiting until next week and then all of a sudden someone says now we need the order. So to the extent
I would like to see the February order.
And I conveyed that to them.
But I also have to deal with the issue of whether, regardless of what the order says, whether there's still a constitutional obligation on the DA's office to review the information that they are in possession of to determine whether it contains exculpatory information that should be produced in other cases. I appreciate the fact that somebody says you can't look at this or you can only look at it for a limited purpose, but I'm not sure that that trumps the constitutional obligation that the DA's office has to review stuff. I'm trying to avoid having to decide that if we can get the authorization from the federal court so that we don't have conflicting orders. But we're not there quite yet. We need to run it to ground a little bit more, and hopefully we can get some movement this afternoon. I think I told everybody last time, out through the 11th. So I'm back the 12th. I'll see you the 12th. I'll see you the 13th. Whatever is convenient for everybody to get back together. I think...
Judge, I appreciate that 100%. My concern is, if we know that we're running up against that clock that runs out on the 18th of August, is there a way that the government can now, or the Commonwealth can now ask the government to extend that order again? I don't want to be in a situation where you finally make a decision.
I think the Commonwealth understands that.
Yes.
And I invited you the last time seek to intervene or to do whatever you needed to do to communicate your concerns to the feds.
I understand that, and that's what I did, Judge. I had a conversation with the U.S. Attorney's Office, had a conversation with their attorney, and the plan was, if we did not hear back in a way that was reasonable to us, both myself and Attorney Sullivan planned to file a motion on Wednesday to intervene.
Okay, great.
That was what we were planning on doing. So that's before we knew that they weren't going to have a meeting until 4 o'clock on Tuesday, Judge.
Yeah. All right. So do you want to set a date? Do you want to say the 12th?
I think the 12th at 2 o'clock, just from my reading of the emails that was going around yesterday, seemed to be the best.
I think that's what Ms. Irwin said.
Sure. Yes.
Okay. So we'll put, let me just see, we will put...
Except for Mr. Wester, I do want to say, who will still be on vacation.
Right. We will put King, De Los Santos, Johnson, and Chanchillo, and I think also Walsh.
Yes, please.
On for 2 o'clock on the 12th.
And these are all cases that are going to be affected by Michael Proctor's misconduct. Well, I guess I should say alleged misconduct, because we don't know what's in those text messages. But according to the interview that Miles King's attorney did, they saw some things in there that showed Michael Proctor might have been saying and doing some things he shouldn't have been doing. Would we be surprised? No.
On the issue relating to the federal Proctor discovery.
Yes, Your Honor.
Thank you, Your Honor.
And is there any way to get an update from the 4 o'clock meeting today, Judge, so that we're not waiting until the 11th or the 12th, the morning of the 12th, to find out what happened?
I'm sure that the Commonwealth will alert folks to whether progress has been made. Everybody needs to be on the same page ultimately for the hearing on the 12th, and you're going to have to act quickly. The Commonwealth may have to act very quickly, depending on what happens.
And I've been doing that.
Yeah. Okay. Thank you.
Thank you.
Thank you, Your Honor.
All right. Now, with respect to the King matter, we're
Here we
just
go.
dealing with the issue of the late disclosure. And
May I be heard, Your Honor?
sure.
At the close of the last hearing, you asked the defendant to provide the court with which documents were either exculpatory or would inhibit the defendant's right to a fair trial, would
All
be
of it?
prejudicial to him. I have not heard of one document since these have been provided in April and May. And
Wow, that statement did not age well, because as we know, we've got Michael Proctor's text messages.
to that end, I'd ask the court to order that right now. I think that this has gone on. This is now the second day of a hearing, and the Commonwealth is unaware of which document or which documents are prejudicial to the defendant and will prevent him from having a fair trial.
We had two things I was looking for. I was looking for that, and I was also looking for some sort of a agreement of the parties, if it was worked out, to identify which of the documents were newly disclosed, which were partially disclosed previously and fully disclosed more recently, and then there was the prejudice analysis as to the new documents.
Correct.
So there was sort of a two-phased process. I don't know whether either one of those phases happened, whether the parties met and tried to work out an agreed list as to what was new or what was not new.
I endeavored to work with ADA Hickman to ensure Your Honor had a complete list as diligently and as best as we could of what documents were previously produced, and that was provided to Your Honor. I believe was sitting on your desk as Monday morning. It was a third exhibit that the Commonwealth provided. We did confer on Friday afternoon. It was represented to me that counsel would be providing us a disagreed list or a number of other lists to show the court what they disagreed with.
I got a pile of documents.
And we got that as well.
This is the pile that I got, I think, from Mr. Piccio's office. I don't know if included in there is the chart that you folks worked out that you say was on my desk. I'm not sure I know what you're referring to in terms of a list that was new or not new, but maybe it is in the stack.
It's a
How do y'all think the Commonwealth feels about this entire situation with Michael Proctor? Can you imagine them getting prepared with their defense and knowing in the back of their mind that somebody's going to bring up Michael Proctor and what he did?
table. It's the third. If you look in the manila folder that's underneath that, there, in a rubber band, it's in your hand. Right now.
Oh, in here, okay, this one.
That, yes. The third doc.
Okay,
That is what I prepared with the assistance of ADA Hickman.
Okay.
Which specifically describes what, if anything, is
Okay.
minorly different. That was provided to counsel on Thursday last week. We met we got a teleconference on Friday, and counsel was working on their own lists.
okay,
So to answer your question, no, there was no agreements as of now. We endeavored to meet earlier and understand from my pleading what counsel disagreed with, but that was not reached. We've provided you, the Commonwealth has provided you as best we can what has been previously provided.
okay.
If there's any subtle differences, we can supplement that at a later date, but at this point, I know ADA Hickman has worked very hard
All right.
to go through the material.
Attorney Scapiccio?
Thank you, Your Honor. So we've provided three charts, both to the Commonwealth and to the court. The first chart deals with the information contained in the Commonwealth's opposition in disputed documents from pages 7 and 8 of your motion to dismiss. The second chart deals with all of the new discovery, which I thought we were in agreement that the second chart is everything that was new, it hasn't been disputed by the Commonwealth. And the third chart is the information.
So you
got their
have
stuff
two
together.
dueling charts, huh? So you have the Commonwealth's chart and your chart.
Yes,
This is exactly what I didn't want to have happen.
I understand, Judge.
So why didn't you get together and work, figure
Well,
out
Judge,
a...
I tried you.
Well, I think we both tried. I'm playing catch up here, Judge. They've had this information since 2021. I'm trying to go through it, organize it, and figure out where it fits in the most timely fashion that I can. And that's what I've spent my time doing. So when we spoke on
And
Friday.
do I have a list of the items which are new or which you claim to be new and that I can then cross-reference against the Commonwealth's list, which you say are prejudicial or are exculpatory and you're behind the 8 ball because of the late disclosure, notwithstanding the continuance.
This is nothing new.
Yes, Your Honor.
Okay,
I am.
where will I find that?
So where we find what, Judge?
Your list of the explanation of why particular things are prejudicial to you.
That hasn't been completed yet, Judge.
Okay.
I just got to the point where I was able to send a list to them literally Monday morning saying, based on everything that you provided since April, here's what I think is new, and we all agree it's new. That's chart number 2. Here are my disputes from what you say you already gave us from the first part of your motion, and here's what we say is new from the second part of your motion. That's what I was able to accomplish in the week that we had between now and the last hearing.
All right. So you need more time to get the other stuff done.
I do.
Okay. How much time do you need?
It depends. I just got more discovery this morning, Judge, so it just keeps happening.
Come on, Your Honor. Like, how much time do you need to review the discovery? You don't know how much discovery there is. It's like, hey, guys, I want you to build me a house. I'm not going to tell you the size of the house. I'm not going to tell you where it's going to be located, what you're going to have to do. I'm not even going to show you a picture of the yard and the area where the house is going to be built. Can you tell me how long it's going to take you to build that house? Like, dang, Your Honor, we don't know what all is there. And now we got these 13 plus years of text messages from Michael Proctor we have to review. Come on, man.
So in order for me to get my hands around it, they have to be able to certify that I have everything, Judge. Because I can't keep doing this piecemeal the way that they've asked me to do it over the last month and a half. So do we have everything? Because if we do, I'm happy to sit down and say this is where we are and this is where we stand. But if we don't have everything and we're going to come back in a week and they're going to hand me something else in the morning of the hearing and say this is now
as an initial crack, I wanted a list of what was new and what was prejudicial in the 2 notices as of when the motion to dismiss was filed.
Yes,
that's what I think we were shooting for. We understood that some new stuff had been produced after that.
Yes.
And I don't know what the explanation is for that, but in any event, we're looking at what was filed as of the time the motion to, what was new as of the time the motion to dismiss was filed.
So, Judge, what I did with the new information is I put it in chart 2 as a description of it. I cross-referenced it to a bait stamp number if we had it, and I put it in a discovery category, which is I thought what the court asked me to do. So some of it has to do with jail calls, some of it has to do with social media, some of it has to do with search warrants. I've categorized it in a way that I think that I was hoping it would help the court understand.
Can we make a record here?
Yes.
You were referring to lots of stuff which is not in the record.
Correct.
Right? We admitted in the last hearing exactly 1 document.
Yes.
Right? If you are referring to particular charts, let's be clear about what they are. Let's mark them as an exhibit. And then we'll discuss what we need to do. You can explain what those documents are to me without a witness. I think that's sufficient. And then we'll decide whether we're going to proceed with the hearing on an evidentiary basis today or not.
Thanks.
Oh, I'm sorry.
And I'm going to leave a link to the rest of this video for y'all in the comments and in the description so you can go watch it. Michael Proctor messed up. He messed up bad. And a lot of this took place before we knew personally about all the text messages, but this whole situation with Michael Proctor was going on. I wonder if he's still going to testify in this Miles King court proceeding, if it ever even gets to that point. Let me know what y'all think in the comments and in the chat. Oh man, what was Michael Proctor thinking? Shout out to the gang. We got 15,000 of you in the building. Can y'all like the video real quick, please? We got half of you. Nearly half of you have liked the video. I'm gonna keep begging for likes. It's free. It's actually not her job to give them all a list of items she believed may be prejudiced. Exactly. The lead, yes, that falls under automatic discovery rule 14B2B, and it makes sense. Like the prosecution just can't keep introducing discovery as the trial goes on, but leading up to the trial. That's not how it works. So yeah, I agree. Saying that this discovery shouldn't be allowed in. That's kind of crazy. The judge is playing in her face. I love the soundboard. Hey, shout out to the soundboard gang. This is going to be interesting to see what's happened. And I haven't seen much of the evidence when it comes to Miles King. I know a lot of you are familiar with that case, but we're going to have to actually do some more digging and figure out what was going on with this Miles King case, and is there maybe something there that we need to look at sideways like we did with the Karen Reed situation? We're gonna have to wait and see and find out. Actually, let me fix this real quick because we're gonna get into this in a second. But before I do,